A commercial contract is essentially a machine built out of words, but no written document, no matter how exhaustive, can predict every single mechanical action required to execute a complex business deal. Eventually, the gears of the agreement will violently seize. When an agreement remains entirely silent on a critical day-to-day operational step, the transaction generates commercial friction. Without a mechanism to bypass that friction, the entire exchange risks grinding to a halt. To prevent this, the legal system relies on a structural safety net known as implied actual authority. This is a legally recognized power that an agent possesses to perform necessary tasks, even though those tasks are never explicitly written in the contract. The law restricts this rescue mechanism to preventing total commercial collapse, ensuring agents do not use it as an open-ended authorization. We can see exactly how tightly restricted this mechanism is by examining the landmark 1967 commercial law case, Australia and New Zealand Bank Limited v. Ateliers de Constructions Électriques de Charleroi, set in mid-century Australia. The target of this litigation was a local branch of the Australia and New Zealand Bank, which found itself exposed to a massive liability dispute over mishandled funds. The case forces a difficult question. How do courts systematically define an agent's invisible power when the contract is silent and millions of dollars are on the line? To solve chaotic factual disputes like this, the legal profession relies on a deterministic cognitive framework called the IRAC model. IRAC stands for Issue, Rule, Application, and Conclusion. We will use this exact matrix to deconstruct the boundaries of implied authority and resolve the multi-million-dollar ANZ bank controversy. First, we isolate the legal issue. This node graph maps the parties. ACEC is the principal, Helios the agent, and ANZ Bank the third party. ACEC appointed Helios to sell equipment. Friction arose when Helios deposited ACEC's checks into its own ANZ account. The complication arose when Helios went bankrupt before it could transfer all the cleared funds back to its principal in Belgium. ACEC sued ANZ Bank for the tort of conversion. Conversion is a strict liability offense where a party illegally handles or retains property, in this case the checks, that rightfully belongs to someone else. This distills the chaos into a single legal issue. Did the agent, Helios, possess the implied actual authority to endorse checks payable to the principal and deposit them into its own account? The stakes are binary. If Helios lacked this invisible authority, the bank committed conversion and must pay heavy damages. To measure whether an agent's invisible power legitimately exists, courts require an objective standard. This brings us to the rule quadrant. The foundational rule of agency law states that an agent inherently possesses implied authority to perform acts strictly incidental to executing their express agreement. But courts apply a severe limiting threshold to this rule, known as the doctrine of business efficacy, or the necessity principle. This scale illustrates the threshold. The law rejects implying authority just because a shortcut is easier or more convenient for the agent. Convenience fails the test. To cross the threshold into business efficacy, the commercial arrangement must be physically or legally incapable of functioning without this implied power. The rule proves that implied authority is not a tool for lazy agents. It is only triggered when a contract faces literal, unavoidable operational failure. In the application quadrant, this rigid legal rule collides with the messy, mid-century commercial realities of the ANZ Bank case. The first major constraint Helios faced was geographical. The principal, ACEC, possessed no Australian bank account of its own to receive local deposits. The second, insurmountable constraint was regulatory. Governments in the 1960s enforced strict international exchange controls. These exchange controls made it legally and practically impossible for Helios to mail the endorsed Australian checks back to Belgium for clearance. The foreign banks could not process them. Viewed through the IRAC lens, Helios was trapped in a mechanical dead end. They were caught between a silent contract that didn't specify payment routing and immovable international banking barriers. The application phase reveals that Helios deposited the checks as a specific, necessary response to systemic international financial friction. We can prove this analytically by presenting a hypothetical alternative to the court. What exactly would happen if Helios strictly adhered to the silent contract and chose not to deposit the checks into its own account? The logistical consequence is immediate. the checks remain permanently uncleared, capital could not cross borders, and ACEC would never be paid for its sold equipment. This chart maps the alternative. The no-deposit route leads directly to commercial paralysis, completely defeating the express agreement. Contrast this. Depositing checks locally cleared the funds through the Australian banking system. Once liquid, they could legally wire over the international barrier to ACEC. The ultimate analytical conclusion of the application phase is clear. Routing funds through the agent's own account elevated the action from merely convenient to commercially necessary. The strict legal requirement of business efficacy was perfectly fulfilled because the primary commercial enterprise physically could not survive any other way. We now move to the final conclusion quadrant to deliver the court's definitive holding, which is completely determined by the logic of the application phase. The formal legal verdict ruled that because the action was a matter of strict commercial necessity, the agent, Helios, did legally possess implied actual authority to endorse and deposit the checks. This ruling resolves the multi-million-dollar liability facing the third-party institution. Because the agent had the invisible authority to act, ANZ Bank acted lawfully in accepting the checks. The bank is completely shielded from conversion claims. The doctrine of implied authority provides a protective legal shield for agents and third-party institutions navigating the gaps in incomplete contracts. Looking at this fully populated matrix, we see how a chaotic international banking dispute is systematically filtered into a single deterministic legal outcome. Contracts are inherently flawed, finite instruments. They can never fully predict the mechanical friction of the real world. While courts will refuse to rewrite a bad contract, they will surgically imply necessary mechanical steps to save a viable commercial arrangement from destroying itself. Implied actual authority functions as a vital operational bridge in commercial law, regulated by the strict threshold of business efficacy and clarified through the IRAC method.